tired and woe-begone, hoarse with making moan, rising from unrest, the trembling woman pressed, with feet of weary woe, she could no further go. At about 2 o'clock one Saturday afternoon in August 1937, Miss Chester's son Maxie went out on the street to play. Maxie was 7 and a half. A few months earlier, Waverley Council had dug a trench in Allen's Parade. In places, the trench was 7 feet deep. Over time, that trench had filled with water. The water-filled trench and a pile of sand dumped there by the council were an irresistible magnet for the local kids. Often council workers had to chase them away. About an hour after Maxie left, Ms. Chester realised he had not come back. The House of Lords decided Donohue and Stevenson in 1932, just 5 years before Chester was decided by the High Court. The modern law of negligence was in its infancy. It was clear that the council owed a duty of care to Maxie. If he had survived, he would have been able to sue the council for any injuries he sustained. Because he did not survive, his claim died with him. Did the council owe a duty of care to Ms. Chester? She was clearly traumatised. The desperate search, the sight of her son being lifted from the water, and the impact of the unsuccessful efforts to revive Maxie had caused her nervous shock. The majority of the High Court held that it did not owe her a duty because her loss was not foreseeable to any reasonable person in the position of the council. It cannot be said that nervous shock resulting from a mother seeing the dead body of her child should be regarded as within the reasonable anticipation of the defendant. It is not a common experience of mankind that the spectacle, even the sudden and distressing death of a child, produces any consequence of more than a temporary nature. The appeal should be dismissed.
In the present instance, I think that her mother's shock on the production of the dead body of her child falls outside the duty of the municipality in relation to the care of its roads. She was not using the road, nor a witness of the accident. The appeal should be dismissed.
In my opinion, the shock of the appellant is not within the ordinary range of human experience. Consequently, there is no evidence of a breach of any duty that the respondent owed to the appellant, and the appeal should be dismissed. Let us apply this criterion to a reasonable person in the situation of the defendant counsel. Such a person would foresee that, by leaving the trench inadequately guarded, it would probably become, especially when filled with water and provided with sand, a very attractive place to children in the neighbourhood of the trench. He would also foresee, when directing his mind to the dangers, that if a child got into the zone of the special danger, his parents might themselves sustain physical injury or illness caused by nervous shock and distress. The appeal should be allowed. Appeal dismissed. No order as to costs. Justice Evatt showed real understanding of her pain. His dissenting judgment was vindicated by Justice Deane in 1984 in Jaensch and Coffey, where His Honour said, "It must now be accepted that the conclusion of Evatt J is, on the facts in Chester, plainly to be preferred to that of the majority." Justice Evatt's judgment is marked by its humanity and its concern with the woman who was before the court. It seems to be hard for lawyers to see those who seek their help and seek justice as more than just causes of action. Maxie, a brilliant 7.5-year-old boy.